jury. When the smoke clears and the dust settles from the accident that you just saw in the video, there are two things. The first, and I in no way want to minimize this, is an unspeakable tragedy. A tragedy of dimensions that involves 5 lives lost. 5 sets of dreams destroyed. 5 futures of relationships, full experiences gone. I don't know if words can express how immense that loss is, and I don't seek to diminish that. But the fundamental tragedy in that vehicle happens in relation to what happens in this car, the other car, a black SUV. When the dust settles, the smoke clears, you'll see multiple doors to this vehicle open. You will see the DNA of multiple people in this car who are seen renting the vehicle 35 minutes before this occurs. Now, I'll get into more details, but I want to talk more generally about what we're doing here today. This specific setup of a courtroom with the bar, the bench, the jury box, and the jury room has remained essentially unchanged for hundreds of years. There are 350-year-old jokes about hitting your knee on that door coming through it. It's been poorly designed for that long. But the reason why in our common law system we have established these standards is not because of any of this. It's about the setting of you, a set of citizens, of peers who can sit and weigh the evidence. Cultures for millennia have had concepts of a quorum, a minyan, a council, a group of people who sit together and deliberate evidence. The deliberative body in history has been venerated, and it is one of the primary protections we have in a democracy.
Objection, Your Honor. Improper argument in opening.
Overruled.
Now, we have gone through a period of jury selection just prior to this. Lawyers call it voir dire. It means to see people say things. We wanted to see what you had to say, and now you get to see what the state has to say. The design of the criminal justice system has put the sole burden on the state to prove each element beyond a reasonable doubt. There are modern trappings in this courtroom. There's screens, there's cameras, there's all sorts of things. But this is the most analog of institutions. This is the jury sitting together, taking their notes, waiting to deliberate, and then going back in that room and discussing what was proven beyond a reasonable doubt. This has been carried forward from the Magna Carta to the Declaration of Independence, through the Civil War era amendments and their redemption in the Civil Rights era. And this is the fundamental basis of why you are here. Now, I'm here and the state's here because we have a fundamental dispute. They think that my client committed 5 acts, or 1 act posing 5 crimes, of depraved mind murder. And ladies and gentlemen, they simply don't have the quantum of evidence to establish that my client committed those crimes. They're also making similar charges of homicide related to negligence, leaving the scene, gross negligence. We will get into all of those details, but understand that there are two fundamental questions here. Who is driving the vehicle and what is his state of mind? Keep your eye on that throughout this trial. My client sits here presumed innocent, and the state has to put forward a case in which each and every element is proven beyond a reasonable doubt. And ladies and gentlemen, they won't do that. Fundamentally, he's not guilty of these charges. Just as we must wait for the smoke to clear and the dust to settle in the video, once the sound and the fury in the courtroom quiets to a time of reflection and humane deliberation, you will see that Mr. Derrick Thompson is not guilty. He was not acting with a depraved mind. What you'll see is a car accident that has an immense and an unspeakable result. The question of tragedy is not what this trial is about. The question presented here in this court is whether or not the state can prove beyond a reasonable doubt that my client drove that vehicle and if he had the specific mental state to commit murder, to commit homicide. And ladies and gentlemen, they simply cannot meet that burden. Thank you.